Good morning. So I'm Charmaine Semono, the Supervisory Legal Practitioner, Criminal Section at the Legal Aid South Africa Germiston Local Office. This is our Facebook Live broadcast. We'll be focusing on Section 35 of the Constitution, the Bill of Rights, the rights of an arrested, detained, and accused persons. If you have any questions during this live broadcast, please leave them in the comment box below. I will be sure to answer them. Okay, now we get to the details of today's discussion, which is the Bill of Rights. We'll be looking at Section 35 of the Constitution, our 1996 Constitution. These are the rights that each and every accused person and arrested and detained person enjoys in terms of the Constitution. Firstly, before we get to it, as part of the legal aid, we would like to mainly explain that legal aid derives its mandate from Section 35 of the Constitution, which says every arrested person, detained person, and accused persons have a right to a fair trial, which also includes the right to be legally represented as assigned by the state. Therefore, that's where we come in as legal aid. Going back to the rights of a detained person, the arrested person, and accused person, the Constitution, firstly, is the sovereign law of our country, and it is the law that finds application before any other law. Section 35 of our Constitution looks at the right of an arrested person, the right of a detained person, and the right of an accused person. I'll firstly go to the right of an arrested person. In terms of Section 35 of our Constitution, which I have before me here, an arrested person is a person that is arrested by the police on allegations to have committed an offense. That person enjoys the following right: the right to be silent, to remain silent upon being arrested, the right to be told of his underlying rights in the language that he understands. That is the right to remain silent, and all the other rights must be explained to the person in the language that the person understands. And the person that is arrested and brought before by the police enjoys also the right not to make any confessions, not to come to court, or to be charged, and not to be kept in jail without a just reason or any other good reason. Then we also look at a detained person. A detained person, this is a person that is kept either in police cells or in jail whilst they are awaiting their trial or to be sentenced. And they also enjoy the following rights. They enjoy the right to be explained of any right that is applicable to them in a language that they understand. And they also have a right to be explained to why they are being detained. They have a right to be explained of their right to a legal representative. And they also enjoy the right to be detained in an appropriate facility, that is now your prison, that is now the police station, and in an appropriate facility with good conditions. That is, they must be given food. They also enjoy the right to be given appropriate accommodation. If they need to study, they have access to study in court and challenge their detention. Why are they being detained? So they also possess that right to go to court and challenge the reasons for them to be detained. Also looking at the accused person. An accused person is a person who has been accused of committing an offense or a crime, and they must be given a fair trial, and they also enjoy the following rights: the right to be treated as an innocent person until proven guilty of an offense that they are being accused of, the right to be told of the charges leveled against them as an accused person, and they also have a right to be given a legal representative of their choice. They can get a legal representative of their choice, that is a legal representative that they can pay or from their own pocket, or if they cannot afford to pay a legal representative, they can then use the services of legal aid, as I've already explained, as we are mandated by the Constitution to be there to represent people who cannot afford to pay for a legal representative. That's where legal aid features. We are there in terms of the Constitution. An accused person also enjoys the right to remain silent, not to make any admissions, confessions that can incriminate him or her in a criminal trial. And they have a right to prepare for their defense and have their day in court. The right not to give evidence against themselves, that is now their confession I was talking about, the admission I was talking about, the pointing out I was talking about. They have that right just to remain silent and not make any evidence that will incriminate them. They have a right during a trial proceeding to call witnesses and to give evidence themselves in answering to those allegations made against them. And furthermore, they have a right to be tried in a language that they understand. And in so doing, they have access to an interpreter. That is, if they speak a language that the court is not conversant in, therefore they can use an interpreter. And if an accused person is sentenced, they must be sentenced within a reasonable time if convicted. And the accused person, if convicted, can also have a right to appeal against the sentence and the conviction to a higher court. That is, they appeal if they are of the view that another court, a higher court, would reach a different decision as opposed to the court of origin, the court that listened to their case initially. They also have a right to have their cases reviewed by a higher court. They enjoy that right in an instance where they are of the view that procedurally things were not done correctly procedurally in hearing their case. They then have a right to have their matter being reviewed to a higher court. And they also enjoy a right not to be tried twice for the same crime. So if you were once arrested for a matter and you are again brought before court for the same matter, you have a right to plead that you have already been tried in a matter, therefore cannot be tried again for the same matter. An accused person enjoys that right. Basically, those are the rights that we enjoy as an accused person, as a detained person, and as an arrested person in terms of our law. And further to that, we must also know that as much as we have the rights, our rights are not absolute, they are unlimited. In terms of Section 36 of the very same Constitution, we need to be aware that there is limits to those rights that we enjoy as accused persons, as detained person, and as an arrested person. The rights are limited in terms of Section 36, which also says that a person that enjoys the rights are pursuant to the law of general application, and they can only extend to the limitation if such limitation is justifiable in an open and democratic society based on dignity, freedom, and equality. And the limit to the right as titled as it is reasonably possible. What this means is these rights, they are not absolute. If it comes to light that the rights, they are justifiable if the limitation is justifiable if it goes to an open and democratic society. It is listed, we look at the nature of the right itself, whether the right affects the dignity, the freedom, and equality, to check if the right is justifiable to be limited. So as much as we enjoy the rights, we must know that there are limits to the specific rights. So basically, those are the rights that an accused person, detained person, and an arrested person enjoys. I'll be open to take any questions.
Thank you. Charmaine, we have a couple of questions.
Yes.
So some people are asking about what you said. If you can't afford a lawyer, you have the right to have one appointed for you by the state, and that's when Legal Aid South Africa steps in.
Yes.
So how does that happen? Where in the process will people be able to encounter legal aid, I say, if they are arrested? Where will they find us? Where will they be able to speak with us and secure legal aid?
Thank you. Legal Aid is an organization with a panel of candidate attorneys, legal practitioner to be precise, who cover the courts on daily basis. So if one happens to find themselves having been arrested and brought before court, then they will get a legal representative from the legal aid in court who will consult with them, take their instructions, and check if they qualify for legal aid, because legal aid is for the indigent and those who cannot afford a legal representative. And the fact that one is employed does not exempt them from getting legal aid. We are guided by, there's an instrument we use as a mandate that we get from clients. We use our LA1. That's an instrument that we use wherein we take a client's application. And on our LA1, we're also guided by the means test, wherein if a person earns less than 8,200, if a person earns less than 8,200, automatically they will then qualify for legal aid. But if a person earns more than that, we also take measures to check in terms of the means test, their expenses, and after having paid the expenses, will they still have money to pay an attorney? In the event that they still cannot, then legal aid comes in and affords our services to them. And in the event wherein a client can afford to pay, legal aid will therefore be denied, but the client still enjoys the right to appeal against the legal aid decision for refusal, and that will therefore be processed by our provincial executive to check if legal aid can be granted to a client. But at most, in all the courts nationwide, you will get a legal aid practitioner who can take applications and be able to represent the client professionally. So
someone is asking about the banner that we have up next to you that says you do
not pay legal aid. Yes.
Could you please clarify that? I think people are hearing what you're saying, that the Bill of Rights says that if you cannot afford a lawyer, one will be appointed for you. So could you please clarify, if you're arrested, detained, accused, will you ever have to pay for legal aid?
No. Legal aid services are for free. As an accused person or family of the accused person or detained person or arrested person, legal aid services are for free. We do not ask for payment from clients that we are representing. Therefore, legal aid services are for free. And we have the fraud hotline. If you are being made to pay for legal aid services, that is not correct. What you can rather do is to report the matter on our fraud line. The numbers are 0800-153-728.
Charmaine, you mentioned that Section 35 says you can appeal your central connection for a moment. Could you just tell the listeners how you can do that? So if you have been sentenced and you are serving time in a correctional center, how is it that you can appeal, and then again, how will you be able to find and reach Legal Aid South Africa to do that?
Oh, okay, thank you. On that note, if one is an accused person and the court finds you guilty, obviously you'll have your legal representative in court, and what can happen is you can then give your legal representative instructions to proceed with appeal proceedings on your behalf. In the event wherein you are in the correctional facility, you have already been convicted, and you have 14 days, you have 14 days to bring your application. In the event wherein 14 days has lapsed, wherein you have not brought your application and you are in the correctional facility, what can happen is you can contact the legal aid through the correctional facility to say that you want an appeal to be brought on your behalf. In this event, wherein we are going now to make an application for condonation, because we are bringing an application that is outside the prescribed time. Therefore, we will come to the facility to consult, get instructions based on your instruction for leave to appeal, and like we normally do. Legal aid even has appeal paralegals that goes to prison regularly to get instructions on leave to appeal. And even our practitioners, we do make prison visits to get instructions on leave to appeal. Therefore, that is how they can access legal aid, and we also then assist them in bringing the application for leave to appeal.
Fantastic. And we're also receiving some questions about, aside from the means test, because we are called Legal Aid South Africa, do we only assist South Africans in criminal matters, or do we assist anyone who is facing an accusation or who has been arrested and detained?
Okay, this is taking us back to what the Constitution says. The Constitution does not make any discrimination whether you are a South African or any citizen outside South Africa. But how the Constitution phrases, every accused, detained, or arrested person. So that would explain that it covers everybody in it, everyone in it, not only South Africans.
Fantastic. And we have a comment here from Malika, who says, instead of a question, I feel that legal aid should be provided earlier, preventing the need for further particulars and being requisitioned for 7 days, minimizing state costs, and being detained for longer periods of time, eradicating infringement on the right to just administration. Do you have a comment on that?
Based on that, I would rather say legal aid is available earlier. Like I said, on your first appearance in court, you will get a legal aid practitioner there who will take your application, who will run with your matter from the first day of your appearance in court. And as to the client needs to be brought to court within, it is in terms of our law that any arrested person must be brought before court within 48 hours. And in that 48 hours, legal aid practitioner will be in court to speed up the process, speed up the proceedings. We do not wait for clients to be kept in custody 7 days before we come in. As soon as the clients appear in court or any accused person appears in court, legal aid is there at their service.
And one last question, by the looks of it. The Bill of Rights does say that, you quoted it, you said that if the accused person speaks in a language that the court isn't conversant in, then they have the right to have access to an interpreter, to be tried in a language that they understand.
True.
So similarly then, if I were to approach Legal Aid SA for representation, will Legal Aid SA be able to provide me with a legal practitioner who can speak my language?
Yes. Legal Aid, it's an organization that has diversity in it. If you are arrested and you need somebody that would speak your language, we would make sure that you are given a practitioner that you'll be able to understand, because at the end of the day, it is more important that you be tried or you formulate your defense and be represented professionally and with an understanding of what you are telling your legal representative, because first thing first, for a legal representative to assist you properly, they need to understand what you are saying to them. Therefore, if they are not conversant with your language, we'll get somebody who's conversant in your language, to an extent that we even have access to experts, and we can also even source out the use of language services from Department of Justice to say, you have, I'll make an example, an Urdu interpreter. Our client speaks Urdu. Can you assist us with an Urdu interpreter so that we can be able to consult and formulate our defense appropriately?
Fantastic. Thank you. I don't see any more questions. I think we've consolidated all of them.
Okay, thank you for joining us today. If you have any further questions on this topic, you can call the toll-free number Legal Aid Advice Line on 0800 110 110, weekdays between 7 a.m. and 5 p.m. If you cannot call, you can send a police call on 079 835 7179. We'll call you back. And be sure to catch our next Facebook Live tomorrow, the 26th of March at 10